Okay, Mr. Richardson, please continue. Just make sure your mic's on or you're in front of it.
I'm both now. Thank you, Mr. Chairman.
There we go.
Ms. Griffin, it seems like your testimony explaining the alternative returns on equity that you calculated seem to be complaining that SC&G can't get a return on equity or profits on the disallowed cost. Isn't that right?
I don't know if it's complaining. I mean, we're just pointing out that those are costs that our shareholders are going to eat.
You're illustrating that the company is not getting a return on the disallowed cost, right?
That's fair.
And you continue on in that first paragraph on page 38 of your direct pre-filed testimony that it says, if imposed involuntarily on prudently invested capital, which the capital reflected in the impairment is, the result constitutes unlawful confiscation of private property in its starkest form. You highlight that sentence. If imposed involuntarily on prudently invested capital, which the capital reflected in these impairments is, the result constitutes unlawful confiscation of private property in starkest form. You're talking about the disallowed cost, aren't you?
Well, I'm talking about the amounts of the impairments that we would have.
That result from the disallowed cost, right?
True. Or yes.
And so, I mean, this statement is not true, is it?
How do you mean?
That the disallowed cost for imprudence constitutes an unlawful confiscation of private property.
Well, I think we're assuming this is prudently invested capital because our view is that these rates were put into effect over time as the costs were being reviewed. And to go back now and change that, the company's position is that that's not necessarily the appropriate thing.
I see. So you're making the legal argument that there shouldn't be any disallowed costs.
No, I'm not saying that. I mean, I think in all the proposals that we've put forward and Dominion has put forward, there are costs that we are saying we will not seek recovery of. And
this commission, is not going to require SC&G to disallow prudently incurred cost, is it?
Well, I think under our proposals, we are voluntarily doing that in some cases.
But you're using more than just what the voluntary write-offs are. Isn't that right? In these calculations?
We are these calculations look at a pro forma return on the electric portion of our business. So it does include more than just the write-offs or the impairments.
But the impairments, you seem to be implying that it only includes those that are voluntarily not being sought. But these calculations include the disallowed costs under the plans too, doesn't it?
That's right. Like for purposes of the ORS plan, we would not be getting a recovery on about $2.5 billion.
And you would agree with me that it can't be an unlawful confiscation of private property of SC&G if it wasn't entitled to those costs in the first place. Isn't that right?
I think based on your hypothetical, yes, I would agree with you. But we're arguing that those costs were incurred and had been reviewed throughout the course of time.
Okay, but just to be clear, I mean, imprudently incurred costs are not the property of SC&G, are they?
We need to prudently incur our cost in order to expect rate recovery from this commission.
And in fact, wouldn't it be a potential taking from the ratepayer if SC&G collected for imprudent costs?
I think you could make that argument, yes.
But this wasn't this. I mean, this isn't really your testimony at all, is it? That about what constitutes an unlawful confiscation of private property.
Well, I think what we're trying to say here, and not to venture too far into the world of lawyers, but if this were imposed involuntarily on amounts that we think were prudently invested, and that the commission had ruled in the past that we could have recovery on based on that prudent investment, then to retroactively change that at this point would not be appropriate.
And you've done a good job of explaining it, but isn't this just the lawyers talking?
I'm sure, as you just saw, my explanation is a little more plain English than the lawyer's version, yes.
Including the lawyer's version is in your pre-filed testimony.
That's right. But as I just demonstrated, I agree with the sentence and interpret it in a more general form.
All right, let's turn to the bottom of page 39 of your direct pre-filed testimony. And look, I'm not going to point out all the times in your testimony that I think there's a legal argument being made, despite the objections here. But let's look at one more. At the bottom of page 39, in agreeing to the customer benefits plan, Dominion Energy's investors are agreeing to a return on SC&G's operations, which, if standing alone, would be far less than what would, if you go to the next page, what would objectively be considered fair and reasonable return under the applicable constitutional and rate-making principles. Do you see, do you remember this part of your testimony?
I do.
That Dominion, you're basically saying, look, Dominion's coming in and agreeing to the customer benefits plan, but if the commission were to decide to do it without Dominion's agreement, it would objectively not be fair and reasonable under the applicable constitutional rate-making principles. Isn't that what it says?
I think what we are saying is, yes, Dominion is coming in with a proposal that voluntarily gives up recovery of, I believe it's about $2.8 billion in assets. So they are willingly doing that. They are agreeing to offer that. We would make the argument that those costs were incurred over the course of time on the project and had been reviewed and put into rates. So to retroactively change that would not be appropriate.
Well, that's up to the commission, though, isn't it?
It is. It's absolutely up to the commission.
Okay. And you testified in the next part of that, starting with and if, that if the commission, it was this what was already up there. Very top 3 lines. That if the commission imposed involuntarily, if imposed involuntarily, but you could, to make it make sense, if the commission imposed involuntarily the Dominion Customer Benefit Plan, it would constitute confiscation of private property for public use. See that?
I do.
Is that your testimony?
It is.
But you're not giving the commission legal advice, right?
I'm not giving the commission legal advice. Again, I think the difference here is the voluntarily versus involuntarily portion. If I voluntarily gave you $20, I think that would be fine. But if not in this circumstance, but if the commission were to, or if you were to take $20 out of my purse, that would be confiscation of property. I think that's the only point that we're getting across is the voluntary versus involuntary.
And is that really applicable in this situation?
I think it's just a point to try to demonstrate that we are seeking to find a balance between our shareholders and our customers.
So Dominion's willing to give the customer benefit plan to commission, but if commission reached out and wanted to order it involuntarily, that'd be a confiscation of private property for public use.
Mr. Richardson, if I might add, certainly I'm not an attorney, but I think the idea of...
Mr. Chairman, I just object. I'm not the lawyer questioning her unless we're going to have a tag team be able to ask her multiple questions. She can explain later, I think.
Okay. Sustained.
No offense, Ms. Nagy.
Thank you.
Thank you. Now, Ms. Griffin, isn't this, again, just the lawyers using you to make their legal arguments?
I don't think that's the case. I mean, certainly we have made arguments in this testimony because we're trying to put our case before the commission. But I agree with the sentences that are written here.
You do?
I do.
Still agree with that?
I do.
The commission can't order the plan, even the customer benefit plan, without the joint applicants volunteering.
The commission is absolutely entitled to do what it thinks is appropriate.
Okay. Let's move on. Let's talk about your compensation and promotion. What was your salary before becoming CFO this year?
Approximately $200,000.
And this year, you're going to make more than $1 million, aren't you?
If our bonuses were to pay out, my base compensation is about $400,000.
And Mr. Addison's base compensation is only about $600,000, right?
I don't know if that's appropriate, if that's accurate or not. I think that's close.
So it's not fair to say that you're only making double this year what you made last year, right?
It is true that my base compensation is double what it was last year, but my level of responsibility has increased probably tenfold from what it was before.
What I mean is it maybe depending on what your goals are and what else is going on with the company. I mean, your disclosures say that you're going to make over $1 million this year.
That's right. A large portion of my compensation is based in bonuses, and if we earn those bonuses, then I would make over $1 million this year.
And you're also going to receive, if you don't survive the merger, more than $3 million in merger-related compensation, aren't you?
That's right. If the merger closes and I lose my job or I'm let go as a result of that, then I would get $3 million.
But as of last year, that wouldn't be true, would it?
That's correct.
Wouldn't even be close to that, would it?
No.
And that merger-related compensation, that's coming out of the $110 million trust, right?
That's right.
Is it true that you've never read the Bechtel reports,
That is true.
even after it became public?
That's correct.
But you have to sign the SEC filings ensuring no material information has been omitted, right?
That's correct.
Do you have personal legal counsel paid for by the company?
I do.
Are they here today?
They are not.
You met with them before coming to testify?
We talked on the phone, yes.
You think that those things, I mean, a lot of that is similar to what Mr. Addison testified last week. You think some of those are related, that y'all have both survived and been promoted, that y'all both being paid a lot of money and promised to get a lot more if you get the merger done, that you both didn't know about hiding the Bechtel reports and hadn't read them, that you're still refusing to read the reports after consulting with the company and with private counsel, that you're CPAs and corporate officers and you know the omission of material facts is fraud and possibly false and possibly fraud, and last, that you're simply testifying that despite this limited exposure to the material facts, that all costs were prudently incurred and that the just and reasonable rate needs to be double what the experimental rate is. Now, my question is, do you think that's coincidental?
I'm not sure if I follow your question. So maybe if you can repeat it for me just a little more succinctly might help.
Right, and not the, I mean, you heard the list of things, and there wasn't anything in there you disagreed with, right? I mean, all those are similarities that maybe didn't occur to you before today, before I mentioned them, but that kind of lay out a pattern of the first two witnesses we're seeing from SC&G in this proceeding.
I think that's fair.
I know,
There are similarities.
Yeah, that's obvious, but the question is, do you think it's coincidental?
I don't know that it's coincidental, and I think the company plans to put forward witnesses that were involved more directly in some of the information that you've asked about. I'm just not that witness. I wasn't in the roles that would have required me to be involved in any of that stuff during the time that it was happening.
And it's that last part that is kind of the additional similarity, maybe, that we saw between you and Mr. Addison. And does that not seem?
Stay in front of that microphone.
Thank you, Mr. Chairman. And it's that last comment that you made that makes it curious, and that's why I was asking, do you think it's coincidental that you both are in such similar positions now?
Objection asked and answered.
Sustained.
Thank you, Mr. Chairman. Ms. Griffin, in the federal court case, you warned that the merger could be called off if the court did not strike down the experimental rate in Act 258, didn't you?
I did.
And specifically, on paragraph 208, you said that the failure of the Dominion SC&G merger will impact energy operations for the entire region. Is that right? Paragraph 208.
That's correct.
And after the court denied SCNG's request to strike down the experimental rate in Act 258, the merger wasn't called off, was it?
It was not.
And you're making the same warning to the commission here today about the same possibility that if the Dominion's plans aren't approved, that the merger is going to get called off.
And I think Dominion's witnesses have even filed testimony in this case that say that same thing.
You also warned in paragraph 214 of the federal court complaint that if the act and joint resolution were to take effect, SCANA could be forced to divest or take emergency measures to raise cash to fund operations, didn't you?
That's right.
And you, going on in your declaration, turn to page 11, probably paragraph 11. You personally attested that, quote, I cannot overemphasize how radical and disruptive the effect of the act on the company will be. It will affect how the debt and equity investors who provide the capital needed to operate our system view the risk of investing in the company.
That's correct.
And you go on in paragraph 34 of the declaration. Last one. We'll highlight. You swore in that declaration, paragraph 34, that the act, though temporary, will nonetheless lead SCNG to suffer immediate, irreparable harm over the course of at least a 9-month period. The experimental rate will remain in place during the PSC proceedings.
That's correct.
And yet, SCNG has not been forced to take emergency measures after the law was upheld, has it?
Well, we have taken emergency measures in terms of reducing the dividend, which made up for the cash loss of the Act 258 reduction predominantly. Yeah. We're not replacing service company positions. Some of that is because Mr. Addison mentioned we're trying to preserve, we don't want to hire somebody and then to have them possibly negatively impacted by the merger. But we're also doing that in terms of constraining cost at the company as well.
And the dividend reduction actually occurred before you ever filed a federal court action, didn't it?
It did. And then we've sustained it since then.
And the attrition that Mr. Addison talked about before is just when not replacing people when they retire?
No, not replacing people when they retire, or as you can imagine, a lot of employees are leaving the company now seeking stability elsewhere. So, but in terms of things that have happened since this federal injunction hearing, so as the commission knows, they regulate our long-term debt here at the commission. Our short-term debt is regulated by the Federal Energy Regulatory Commission. And typically, we make a filing with FERC every 2 years. They approve that, and then we come back 2 years later to make that filing again. And that authorization allows us to issue commercial paper and other short-term borrowings. When we had that authorization expired this October, and we made that filing with the FERC. It took a bit longer and was a little more difficult to obtain. We were only able to obtain a 1-year authorization, and that authorization has several conditions in it. So they've looked at our financial situation and our financial statements that we've provided and have concerns about our finances going forward.
Concerns. And in August, you placed another $700 million, right, in
That's correct.
Debt at both 3.5% and 4.25%.
That is correct.
And so, isn't it true that SCNG did not suffer immediate irreparable harm after the injunction was refused by the federal court?
I think that's debatable. Certainly, we were able to place that debt. We continue to have trouble accessing the commercial paper markets, which is talked about in my testimony. We talked about the rates that we're paying in the testimony. We also have a subsidiary, South Carolina Generating Company, which contains our Williams Station facility down in Charleston. So it's a coal facility down in Charleston that's in a separate subsidiary from and it sells all of its power to SCE&G. So it was set up that way years ago in order to keep customer rates low when we put that unit into service and made some upgrades to it. That station had $160 million of debt that was due this year, and we sought investors, not your typical utility investors. We even branched out outside of that to try to find the ability to place that debt. We were able to piece together enough to come up with the $160 million, but the rates that we were getting were 10 to 12%, and that was for 3-year debt. So rather than go forward with that, right now what we've done is fund that money through the utility money pool. So in essence, SCE&G has given GenCo a loan to float that debt for a period of time. But that's not a sustainable position. We would need to do something to term that out longer term.
Tell you what, I really want to finish with the financial condition of the company. I got a few other issues I want to deal with.
Okay.
I appreciate you going through that. I want to go back to the bonus payments for a second, and because part of what you were testifying about is at-risk payments that are made to management who lose their jobs after the merger.
That's right.
Did any of the 5,000 construction workers get any at-risk payments after they lost their jobs from abandonment?
I don't have an answer to that question. If they were SCE&G employees, they did receive some severance, but I don't know about the Westinghouse and other consortium employees.
So the 500 SCANA Services folks who lost their jobs after abandonment or since abandonment, they got at-risk payments?
They would have gotten severance payments, and if they were participating in our bonus programs to the extent those paid last year, they would have received those payments as well.
Not all of them.
Not all of the employees, or
All of those that lost their job would have been part of that bonus system, would they?
that's possible. All employees are part of one bonus system or another, but if they weren't SCANA employees, they would not have received those.
Do you think that ratepayers, I guess we've already dealt with that, Mr. Addison, about whether ratepayers should pay for bonuses or these golden parachutes?
I think I agree with Mr. Addison's assessment on that.
And we talked a little bit about these top 4 members of senior management on the project. And they are, at least the way I'm grouping them, Mr. Marsh, Mr. Byrne, Mr. Addison, and Mr. Archie. In 2016, they made...
Chairman, we've plowed this ground multiple times, and I would certainly ask that.
I agree. Has sustained. We need to get to something new.
Thank you. I actually, Mr. Chairman, we had put in through 2016, and I just wanted to put in through 2017. We didn't have that before, and I've got just 2 questions on that, if that's permissible.
Briefly.
Thank you. You can go to the spreadsheet. In 2017 alone, these 4 men made over $16 million. Isn't that right, Ms. Griffin? Salary, vested stock options, and non-equity incentive plan and bonuses. You waiting to see the spreadsheet?
Yeah, let me see the spreadsheet, please.
While he's pulling it up, it's Addison and Byrne were actually identical numbers. 2.1 million invested stock options, 660,000 in salary, 619 in non-equity incentive plan and bonuses. And if you can get the spreadsheet up, it's interesting that it shows 30% of Mr. Addison's non-equity incentive plan was actually tied to the project in the far right column. Can you just highlight the very top line? I think that's 2017. The tab at the top. No, I want 17. And Mr. Marsh had a 1.27 million in salary, 5.8 invested stock, and 1.4 non-equity incentive plans. Do these numbers to you as CFO sound reasonable and sound correct?
Yeah, I think they sound reasonable.
Mr. Archie's total was 1.48 of those three aspects, that total 16.5 for the four of them for 2017. All right, I promise you to move on, Mr. Chairman, I will. Let's talk about rates of return, Ms. Griffin. Is it the impact of any plan on the customers is best measured by the net present value of the total N&D cost recovery? Don't you agree?
If you're looking at a customer on the system today, I think I could agree with that, yes. If you're looking at a customer longer term, who's going to come on the system later, I don't know that that's the most appropriate analysis, but.
So the other way that the bills will intersect with the customers is the average monthly bill for a typical ratepayer, right?
That's right.
But really, those are the only two measures that we have of where the rate connects with the ratepayer, right? The net present value of total cost recovery, that's over the entire amortization period, discounted present value, and then the average monthly bill for the typical ratepayer, right?
Yeah, I think most customers are probably concerned with their monthly bill.
That's what they see every.
That's right.
Let's talk about the savings from the Tax Cut Jobs Act. That's revenue neutral to the company, isn't it?
It should be.
And so every dollar saved by the company is passed on to the customer, so it shouldn't impact the company's cash flow or reserves, right?
In most cases, that would be true. We have a net operating loss that we'll have to carry forward for a period of time because of the abandonment deduction. So we're not a tax cash payer right now. So it does impact us negatively. So in essence, we'll be giving cash back to customers, but we won't be saving that cash because we're not paying taxes right now because of the NOL.
You're not paying taxes in the current year, but these are ultimate savings to the company, right?
They are savings to the company from an earnings perspective.
Right. And SC&G's promised to pay all of these tax savings to ratepayers, right?
That's right.
And Dominion has made that commitment too, haven't they?
That's right.
All right. And you're familiar with the letter that Mr. Burgess sent on January 24th, 2018 in the other docket, 2017-381-A?
You might have to refresh my memory on that.
There's
a lot of legal letters.
Let's look at the sentence where that confirms that. If the joint application is approved and if the proposed merger between those companies is concluded, Dominion has committed that it will pass the full amount of the tax savings arising from the change in tax law to customers, irrespective of the effect on SC&G's ability to earn its allowed returns. Is that right?
That's correct. And
the Tax Cut Jobs Act has two parts, right? One's this deferral account we've talked about. One time is for 2018, and that'll be paid back. ORS says that's about $68 million. You actually say that's $100 million, right?
That's right.
Okay, we'll take your number. And then the other is the annual savings every year after that. ORS says it's $98 million. I couldn't find where y'all quantified it.
Yeah, and I don't have that number right in front of me, but we're committed to giving back the full amount.
And these numbers that we're talking about now are totally separate and independent of the N&D cost recovery.
That's correct.
So when Dominion puts its chart up there, plan comparisons, and we've talked about this already, the experimental rate doesn't have the savings from the Tax Cut Jobs Act because they haven't been included yet. And do you know if the savings from the Tax Cut Jobs Act is included in either of Dominion's customer benefits plan?
Yeah, my understanding is it's included in all the other plans on that paper, except for the initial bill. So the first column, right. It's not included there, and then it's not included in Act 258.
So the full revised rates, because it was in effect now.
That's right.
For the temporary rate, okay. And if the savings are included in the plans, for example, the customer benefits plan, then the N&D cost recovery is really much more than what's being represented in their monthly rate, isn't it? Because the Tax Cut Jobs Act savings could be shown separately, but they're not. And so it's a huge savings that's built into their monthly rate, isn't that right?
Yeah, I think if you split the two out, there are two components that are going into the total reduction. The reduction for the N&D piece and then the reduction for the Tax Cuts and Jobs Act.
We really have to think about these two pieces that we started with in the beginning of this cross-examination, that there are two pieces to the rate change here. One's N&D cost recovery, and the other is independently the savings from Tax Cut Jobs Act.
That's correct.
And so for the experimental rate, for example, you could just add the savings to that to get a true comparison of the plans, including the experimental rate plan, right?
For the experimental rate, I'm not quite sure how we would calculate the tax cuts. I mean, I think you could go back and calculate that, but I haven't done that math.
But if you added them in, it'd be a lot less than the 125.34, right?
I think I'd rather have someone else answer the details of that question, because I'm looking at a spreadsheet now that causes me to think that it does have some that's included there. So I think it'd be better for one of our tax witnesses to really address that.
All right. Let's finish with the financial condition of the company. I mean, there's no question SC&G is able to meet all of its debt obligations and make all of its payments under the experimental rate. Isn't that right?
We are currently meeting our debt obligations, yes.
And SC&G is not facing a liquidity crisis right now, are they?
We, like I said, have had trouble accessing the commercial paper market. We've had trouble refinancing some of our debt. I think those are certainly liquidity challenges. Would I deem them to be a crisis? Not at this time.
And SC&G is not facing insolvency either, is it?
Not currently.
And Mr. Ziegler earlier suggested in his questioning of Mr. Colin or Colin, that SC&G may have to borrow $10 million a week, but that's not true, is it?
We are in the market for commercial paper daily for millions of dollars.
But SC&G doesn't have to borrow $10 million every week, does it?
I don't know that I've divided it out weekly. That fluctuates based on the time of year. So I'm not trying to evade your question, but certainly we're in the market for hundreds of millions of dollars of commercial paper on a regular basis.
I think his number came from the $500 million that we've talked about, about 50 weeks. And the point being that cash from operations provides much of the capital investment for these annual service and investment charges. Cash
from our customers definitely does help, but our business is cyclical, and there's a lot of investment that takes us many years to recover. So it doesn't give us all the funds we need.
And SC&G is going to refinance more debt before the commission's order comes out, isn't it?
Not that I'm aware of. I don't think so.
Two tranches coming due in November.
That is the debt that we issued early. So we issued that in August to pay for that November maturity because we weren't comfortable waiting until this last minute to try to place that debt in the market while we were here before the commission.
That sounds very prudent. Those debts that were replaced, though, they were being paid at 5.25% and 6.5%, weren't they?
That sounds right.
And this SC&G is asking the commission in this proceeding to allow it to charge the average weighted cost of debt at 5.58 or 5.56, according to our calculation.
That's correct.
Even though it's only occurring 4.25% on the margin.
But you're looking at just the most recently issued debt. That 5.58% is really the cumulative cost of debt that we've accumulated over the course of time.
And it's going down, isn't it?
Currently it is because Treasury rates are really low, but the broader economics to drive that.
And so even if there were credit downgrades that you've testified about, which are far from certain, even under the experimental rate, being made permanent, then the result of those credit downgrades would only affect the issuance of new debt, right?
That's correct.
And is it true that SC&G's retained all the finance cost savings from using the Toshiba guarantee to replace short-term debt?
What we did with the Toshiba money is we had accumulated over $700 million of short-term debt that needed to be termed out longer term. And if we had termed that out longer term, we would have paid an interest rate of about 3.5% was our estimate at the time. So we were able to get the Toshiba proceeds and use that to pay down that short-term debt rather than having to issue long-term debt. If we had invested the Toshiba proceeds instead, we would have maybe earned about 1% on them. So we thought it made sense to use those funds to pay off the commercial paper.
But SCNG didn't defer those savings as a regulatory liability for the ratepayers, did it?
But it did not.
And did the commission ever approve the company retaining those savings from the Toshiba?
They have not. We've put that matter before the commission in this case to ask how to best give that Toshiba money back to customers.
Right. And during construction, SCNG and SCANA have been paying out dividends for most of the financing costs collected from ratepayers and revised rates. Isn't that right?
We have paid out dividends during construction. That's right.
I want to show you what was part of SCNG's response to the third set of ARRs. This is 3.1 or 3-1, served on March 20th of 2018. It's page 88. Do you recognize this chart?
I do not.
This chart was 3.1 asked for all the documents that SCNG provided to the House and Senate. This particular one was provided to the Senate, as indicated in discovery. Does it show, if you can read them, the total dividends each year of the project?
It does.
And I can't read them from here, but they roughly start in 2009 at $230 million. You give her one. Mr. Chairman, can we mark this as an exhibit, the next hearing exhibit?
It'll be hearing exhibit number 91. Will you identify this one more time so we can get it
Thank you,
written in
Mr.
right
Chairman.
correctly?
This is posted on ORS's website, but it is a page 88 of SCNG's response to the third set of AIRs, specifically 3-1. It was served on ORS on March the 20th, 2018. It is a chart that SCNG says was provided to the South Carolina Senate in response to questions. And then I wanted to ask Ms. Griffin about the dividends, and I might mention, Mr. Chairman, that we referenced the January 24th, 2018 letter in docket 2017-381-A, and I intended to mark that as a hearing exhibit as well, even though it's in the PSC filings, and I do not have a copy of it, but I would ask that we be able to submit that letter as a I don't know if the right term is late filed exhibit or just a judicial notice of the commission docket.
Mr. Chairman, just for a point of clarity, was that the letter that he flashed on the board that I had signed? Is that the one you're talking about?
Yes, that is your.
And I believe that letter was filed with this commission, so I would have no objection to that. Go ahead. And if he wants to make an exhibit in this proceeding, that's perfect.
Go ahead.
Yes, sir. What was the date of that letter again, please?
January 24th, 2018, filed by Mr. Burgess in docket 2017-381-A.
Okay, so we'll make that number 92.
And Mr. Chairman, just for clarity.
Yes, sir.
I believe that was the docket that the commission initiated, respect Tax Cut and Jobs Act, all utilities.
Okay.
That's right.
Right, yeah. Thank you. Thank you. Thank you.
Mr. Chairman. Ms. Griffin, in hearing exhibit 91 in front of you and on the screen, do the SCANA dividends by year appear to be correct?
Generally, I would say yes, they do. I have no reason to dispute them.
All right. Does it also show the estimate that SC&G says came from the BLRA revised rates?
It appears to.
And these numbers show that in 2017, the last year of the project, $120 million estimated coming from revised rates. Do you see that?
I do.
And do you see what the total is in 2017? It's $350.
Yes.
And if you go back to 2009, the SCANA dividends prior to the project really getting going, or before revised rates are being collected at any large amount, you see the difference is exactly the $120 million from the BLRA rates in 2017.
Sorry, could you? In 2009, I see $3 million.
No, the top line would be the total SCANA dividends in 2009 are $230 million.
Yes, yeah, I see that.
And then in 2017, the estimate from revised rates is $120 million, and the total is $350 million. Do you see that?
I do.
And the starting dividends in 2009 adding the BLRA revised rates dividend portion in 2017 yields exactly the amount of dividends paid in 2017. Do you see that?
I do. If you take 230 and add the 120, you get 350. That's right.
And so at least for that example, it shows that all of the increases in the dividends during the life of the project were funded for the most part from revised rates collected from customers. Isn't that right?
I think you could make that conclusion from this. I'm just not sure how these BLRA dividend estimates were estimated.
So while the experimental rate is in effect, SC&G is making all debt payments and still earning sufficient profits to pay millions of dollars in cash dividends every quarter. Isn't that right?
We are making all debt payments. I would just point out that SC&G is only paying dividends from its gas business.
And it has the $110 million in the irrevocable trust, and it's also got other assets worth millions of dollars, like the Pine Island playground out at Lake Murray and the beach retreat down at Sullivan's.
There are other assets the company owns, yes, land and such.
And the gas business in North Carolina worth over $2 billion.
That was an offer that we received, yeah.
And what about what we talked about in federal court? Is the company's man who's in charge of cutting trees and keeping them off the lines, is he still able to do his job?
He is.
Okay. I don't have any other questions, Mr. Chairman.
Thank you. Mr. Nelson.
Sniggy, thank you for your patience. I appreciate your sitting up there all this time. I've got a few questions. I'm not going to say that it's going to be really short, but I'm going to make sure that we get done pretty quick. I want to start with, I got about 3 topics or so that I want to cover. And the first one I wanted to talk about was the Toshiba proceeds and your positions on that. Am I correct that you contend in your rebuttal testimony on page 4, starting line 10, that the $85 million in potential lien payments should be reduced from the Toshiba proceeds to be credited to ratepayers?
Yes, I think that I support the position that the company has put forth to net those against the liability.
Okay. Would I be correct in qualifying these as potential payments?
Yes, I think in my testimony is clear that this is the estimated amount, and the final amounts have not been determined. And so in my testimony, I was indicating that it's the nature of the payment versus the amount that I was speaking to. So if the final amount were to be a different amount, would propose that that amount, when it's finally concluded, would be the amount that would be netted against the payment.
But essentially right now you're asking for $85 million to be set aside and not given back to ratepayers. Isn't that right?
I'm here to educate related to specific accounting topics. I'm not advocating that occur. I'm indicating that my testimony is that it's appropriate that based on the nature of the liens that to the extent the company is required to pay those contractor liens, that they properly be netted against the liability.
But that amount isn't a known and measurable amount right now, is it? Because that's just a potential payment. There's a potential.
I think the company in its testimony has given that that's the estimate. So I think it is known and measurable with respect to the fact that it's an estimate based on the amount of the asserted liens.
But if you're estimating a number, that's not a known and measurable number, isn't it? I mean, it's a guess, right? It's an educated guess, granted, but it's a guess.
I would characterize it as an accounting estimate.
Could you, your rebuttal testimony, again, going to that, and on page 4, lines 16 through 19, you stated that, I'm going to quote it here, you can check me, contractor liens related to this construction project, the extent determined to be valid claims, would seem to relate to costs which were incurred prior to the cessation of the work on the project, July 31, 2017, or during the early wind-down period. Is that a correct statement I've just restated?
You've read my testimony correctly.
Yeah, thank you. Is what you were saying in the sentence that I just read, are you saying that you not only don't know how much, if any, of the $85 million SC&G is asking for has actually been paid to lien holders, but you're not even sure if the company's not even sure if these claims at this point are valid claims?
So I'm not an attorney. I don't think it'd be appropriate for me to speak with respect to the matter associated with the contractor lien payments. But if you read further down in my testimony, the purpose of that statement that you just read was to give background and context associated with the contractor liens. And so I continue to explain based on what information I had read and reviewed, on which it seemed that these costs related to periods prior to September 30, 2017, and which related to costs that had been performed prior to that date, and that appropriately, based on the nature of the Toshiba proceeds, would reasonably be netted against it in any amount that would be refunded to the customers.
Do you know if any of those amounts have been paid to date? Is there any amount of those liens that's been paid, to your knowledge?
I do not know.
Is it your position then, or is it your testimony that there should be no return on the Toshiba proceeds, regulatory liability, because the company did not earn a return on the NND costs incurred after it terminated construction?
My testimony is that the liability related to the Toshiba proceeds, which also relates to the NND costs, that amount should be symmetrical, and so that liability should not earn a return given the treatment of the related given the treatment of the related NND costs.
Wouldn't you agree with me, though, that SC&G wasn't paid these amounts from Toshiba to cover its financing costs after it terminated construction? That wasn't the purpose of that payment, was it?
I think that's outside the scope of my testimony.
Do you have any, going to the Toshiba payments again, and I don't know if this is in your area or not, but when the Toshiba proceeds were paid to or monetized by SC&G, do you know when that occurred?
Do I know when the payments were?
When the money was obtained by SC&G?
I don't recall the specific date.
Do you have any knowledge of what that money, what those proceeds were used for by the company?
Only what I have read, publicly available information, as well as some discussions with the company.
Okay. And what is that then? What is your understanding?
I think that would be duplicative with other testimony that's been given by other witnesses.
Was it used to pay off debts? Is that what it was used for primarily, to pay debt?
I think Ms. Griffin in her testimony has covered that and has also answered questions about that this afternoon.
Do you have any idea, assuming then that it was paid off debts, and I can't go back and look at all that testimony, but assuming it was paying off debts, didn't that save the company a certain amount of money by paying their debt off early with those Toshiba proceeds?
Well, so the company continues to pay, as has been covered today, continues to pay substantial interest related to the NND costs for which it receives no return.
But this money that was paid to SC&G was then used by the company, and in so using that money, the company was actually saving a good deal of money, weren't they, by not paying the interest on those debts anymore?
I think my concern in pointing it out within my testimony And again, I would point out that my testimony is fairly limited in scope to point out items that, from an accounting perspective, just frankly don't hold together with respect to certain aspects of ORS testimony of witnesses. And so specifically pointed out the Toshiba issue and the issue of the return because it's frankly just kind of single issue rate making. And so I think that if taken together, all the items are properly considered, then that would be, as I said in my testimony, appropriate for them to be treated symmetrical. It's similar to the issue that I was not allowed to answer earlier with respect to questions being asked around things that are clearly retroactive rate making. And so my point with respect to the Toshiba proceeds is simply that that's single issue rate making and how it was being considered, and that it should properly be considered in the context of the NND cost and the return that those costs are ultimately allowed to receive through the order of the commission.
Talking about single rate making, there are single issues in rate making. You're talking about we should consider or we shouldn't consider this $85 million as a part of the overall rates the company is entitled to under the NND petition here.
I'm sorry. I thought you were talking more broadly about I thought you had shifted more broadly about the Toshiba proceeds. So the $85 million would seem to, given the nature as to what it relates, would seem to properly be if the company is ultimately found to have to repay those. And currently the estimate of the amount is $85 million. That $85 million, given its nature, given its origin, would seem to reasonably be netted against the amount of the liability that's been recorded.
So if the company is allowed to retain by the commission to retain that $85 million, is there a period when there would be an actual true-up? I mean, they're just going to keep that money under the NND rates, right? I mean, these rates are going to be set going forward on this. There's no further opportunity to review the propriety of withholding that $85 million from ratepayers, is there?
I don't agree with that, and I think that there's been other testimony that I have read at some point that in the company's testimony that actually proposes something different than that. I don't believe it was proposed as an $85 million and that there would be no true-up provision.
Didn't SC&G record these costs as a regulatory liability in September of 2017, which means that SC&G considered these amounts due and payable to their electric customers?
I would not be able to speak to the company's conclusion, only what its disclosures were at the time in its public filings.
So it did book those amounts as a regulatory liability. Would that be correct?
Mr. Chairman, I would object to this line of questioning on the grounds that it's duplicative. ORS has covered the Toshiba guarantee money ad nauseam.
Get closer to that mic.
ORS has covered the issue with the Toshiba guarantee money ad nauseum with Ms. Griffin, and I would ask this commission to instruct Nelson to move on.
Okay, we'll sustain that, and we need to. She's answered the question, so let's.
I'll move on to the next subject. And I want to talk about the sales and use tax a little bit next, if we could. Ms. Nagy, is it your testimony that any contractor liens or sales taxes which may be paid in the future or incurred prior to September 30th, 2017 under accrual accounting methodology?
So my testimony is that because the sales and use taxes, if the company were found to owe additional amounts, would relate to purchases that would have occurred prior to September 30, 2017, that the related sales and use tax should be included with those purchases as an amount incurred prior to September 30, 2017.
But wouldn't you agree with me that under accrual accounting, costs cannot be recorded unless or until there is a transaction that establishes a liability?
So I think that based on my understanding of the sales and use tax matter, if the transaction actually occurred prior to September 30, 2017, it's later that the treatment has been disputed. And so similar to when you're dealing with purchase accounting in an acquisition, that there are amounts that if there is a subsequent change, but the liability or the cost existed at the date of the merger, then you have a window, right, with which to go back and record that. I think what's difficult here, and I certainly considered this matter in preparing my testimony, it's difficult to reasonably conclude that sales and use taxes for a particular period could belong, from a matching perspective, in any other period than the period in which those purchases were made.
We're talking kind of, and going to kind of a speculative argument again, I guess, is that this amount that we're talking about, this sales and use tax, that this is not a defined amount at this point, is it? It's not a known and measurable because the company has appealed the tax assessment. Isn't that true?
It's my understanding that the outcome of the appeal is still pending, yes.
So, and going to the last point on this question, do you agree that the company was not assessed sales tax by South Carolina Department of Revenue for tax-exempt materials and equipment purchased for VC Summer Units 2 and 3 until the abandonment and the proposed assessment itself was not issued until May of 2018?
That's not completely consistent with my understanding, but I do want to defer to the witness that I believe is discussing tax matters.
All right. Just got a few more questions, and this maybe goes more to the transmission issues. Would you agree that no contract or lien costs or sales and use tax were incurred to date? And again, in your rebuttal testimony, you assert that there could be an impairment disallowance under ORS's recommendation to defer the entire BLRA transmission revenue requirement. Can you give us the basis for your assertion of that?
Sure, and I realize that the comments there. So in my testimony, I was trying to provide some accounting caution that depending on the wording of the order from the commission, that there's some additional risk. So in Mr. Collins' testimony related to the ORS plan, it was proposed that those costs would be deferred and the prudency of those costs would be considered at a future date. So there is a concept under the accounting standards, specifically under 980-360, of an indirect allowance. And so whenever, as a former auditor and current consultant with respect to, and former controller with respect to accounting matters, it gives me some pause and concern when I see language that says for a company to later down the line that those costs will be considered for prudency. My other cause for concern is that there was, in fact, a rate that was proposed by the ORS witness associated with those costs. However, the incremental borrowing rate is actually what's required to be used by the company in considering the present value of that asset. So to the extent the amount that is, in fact, allowed to return on that asset is less than, so the company would have to, if there was an indirect disallowance, would have to discount that back. There's significant judgment around that, and I'm certainly not forecasting what the company's conclusion would be, merely pointing out that the testimony did not really consider the potential for that impairment and making sure that the commission understood that the order and the wording of that order could be important to the accounting around those specific transmission costs.
So you're saying basically that there is a potential impairment disallowance. Would that be correct? And that's your concern?
Consistent with my testimony, anything that would represent an indirect allowance, even an indirect allowance, would create the potential for an impairment evaluation by the company, yes.
But isn't, and again, going to Mr. Collins' plan, didn't his plan include a deferred long-term debt rate of return on the entire BLRA transmission costs, as well as deferral of depreciation and other transmission-related operating costs?
That's my understanding from his testimony, although I think that similar to other assumptions made, his rates didn't take into account the impact of this very proceeding and of the order. So I don't think he took into account the impact on potential borrowing rates in the future.
And potential borrowing rates we're talking about, again, I guess y'all are taking the position that there's some type of difficulty in getting good rates or in floating debt. Is that true?
Well, I think as Mr. Richardson presented, earlier this afternoon, the company, in fact, in August, when it went to the market to refinance debt that was coming due later this year, in fact, did experience a meaningful premium relative to other utilities in order to access for similar length of time, a similar maturity date. So that would seem to be indicative of that risk, and I think is certainly expected given the proposed plans.
Get into this just a little bit more. I've only got a few more questions here.
Sure.
In his direct testimony, Mr. Colin seemed to recommend that recovery of the BLRA transmission cost and revised rates should be terminated, and that these costs should be deferred until the next base rate case. And did you disagree with that position that he took?
So I, in my testimony, was pointing out the risk of triggering an impairment by deferring without having some clarity around the potential recovery of those costs. And so I think that the company and the joint applicants have put forth a treatment associated with those. My testimony was limited to making sure it was clear that to not follow what had been proposed, and specifically to follow what ORS was proposing, had some additional ramifications that I don't think were contemplated by the ORS witness.
This might be outside your expertise, so I'm not. You can answer this if you can. But we're talking about these assets, these transmission assets. Do you have any particular knowledge of what specifically we're talking about? Switch yard, transmission lines. Do you have any knowledge of that?
So I certainly understand that based on the nature of the assets, that largely they're already in service, and that. My understanding is if in fact they had not been part of the BLRA, they would have been put in rate base in the normal course. And so they are assets that, without, regardless of the abandonment of the nuclear project, are useful assets that are serving customers.
So you're not aware of the fact that the switch yard that they built out there is supposed to handle 3 nuclear plants instead of just 1?
I have not reviewed the engineering diagrams. No, that's outside the scope of my testimony.
So you didn't really consider whether or not these assets were used and useful in determining the numbers that you presented. Is that correct?
That was not the nature of my testimony. The nature of my testimony was related to these costs and whether how they would be treated and the accounting implications potentially thereof.
Thank you. That's all the questions I have. Thank you.
Thank you. Other cross. Commissioners. Mr. Elam.
See if I can get around all my paper here. Initially, Ms. Griffin, good afternoon. Hearing Exhibit 91, that you were being asked about the total scan of dividends declared over the years from 2009 to 2017. Do you have a copy of that?
Do.
These are just a report on each year distinctly. There's no rolling total going on from 2009 to 2017. Is that right?
That appears to be the case.
Okay. I was trying to understand the $230 million from 2009 and the $120 million, or how that added up. It's each year, correct?
Yeah. Yes, sir.
Okay. You said in your testimony that you had not read the Bechtel report, correct?
That's correct.
Have you read a summary of it?
I have not.
Has somebody briefed you on it?
I've heard conversations that we've had at the company, and I've heard conversations that have happened here, but I'm not a construction expert, and at the point that I became CFO, we had already abandoned the project, so I haven't read it. If I were to read it, I think I would have to rely on the construction experts in the company to help me understand what the information was, so I have not read it.
As would I. Changing topics, the SCANDA services employees on site, how many were let go?
I believe there were close to 600 that were
Okay.
SCANA or SC&G employees.
All right. When Mr. Collin was here, he said that there were, if I recall, about 1,750 SCANA Services employees in Casey now. Is that correct?
That is roughly correct for SCANA Services, yes, sir.
And his estimate on how many would be let go was about a third.
Right, I remember hearing that, but that 1,700 includes probably about a third of that 1,700 are call center employees and some gas service employees that are really more operational in nature. And my understanding from Dominion is they don't plan to change a lot of things related to customer service and operations. So you're probably looking at 2/3 of that number that are true SCANA Services employees in Casey.
Okay. And of those, what is the expected loss as a result of an approved merger?
We don't know that at this point. I know Dominion has committed to spending a couple of years working through system changes and working through attrition, and that they've even said to our employee groups they're hopeful that they'll be able to accomplish any headcount reductions through natural attrition. So I think they're planning to work that out over time.
Has the date that Dominion, and they may be the ones who have to say this, but has the date changed? I believe it was at the end of next year, 2019, that there was some sort of guarantee till. Has that changed since the filing of the application?
The date hasn't changed, and they probably can address this much better than I can, but they've committed that employees would get pay continuation through the end of 2019 or the Dominion severance plan, which is based on years of service, whichever is more. So for a lot of employees, they would probably fall under that severance plan.
Okay. Another topic. If Act 258 rates are made permanent, what amount of N&D cost would the company recover under those rates?
I think if Act 258 were made permanent, it looks like the company would be able to recover capital cost of about $1.2 billion. But I do believe that Dominion, in their alternative plan, has worked on a structure that would basically accomplish the same average rate, or generally the same average rate for customers. It's just structured a little bit differently, but they worked back towards that same total.
So, under Act 258 rates, how much additional reduction in rates would be required due to the Tax Cut Jobs Act?
I don't have that number before me, but we can get that to you with one of our tax witnesses.
Could I get a late filed exhibit? Or if you just said one of the tax witnesses will have
we have a tax witness that's coming. I think they could probably speak to that.
Who is that?
I believe it's Mr. Jim Warren.
Okay. Okay. All right. Thank you.
Okay, thank you.
Commissioner Williams.
Mr. Chairman, thank you. Ms. Griffin.
Thank you.
Thank you for being here. A couple of questions for you. See that the time is fleeting. I'm referencing chart G, I believe it's page 36 of your pre-filed testimony.
Yes, sir.
Now, you state that the resulting returns on rate base overstate the actual returns that would be earned on capital invested in SCENG's electric utility business because the impairments reduce rate base without any change in income. Is that right?
That's right.
Okay. Is it your testimony that SCENG's investors are entitled to a return on impaired assets? If so, why is that?
I think that's not my testimony. We're just making the point that when we put those impairments in place, we're basically assuming a 0% return on those impaired assets. So what investors are earning on going forward is the remaining balance.
Okay. And And so in a non-regulated business, if assets are impaired, are investors able to recover a return on those impairments?
In non-regulated business, I don't know that I could speak to that, Commissioner Williams. In a non-regulated business, I think the company could set their own prices and rates. But I don't know that I could speak to that because the only non-regulated business we really have is in Georgia, and we don't have assets in that business.
Okay. If it is determined that the company imprudently invested in assets that are now impaired, should an investor expect to receive a return on those items?
No, sir. I think under these plans and under the Dominion plan, we've assumed that investors are not going to get a return on the impaired assets.
Okay. Thank you.
Mm-hmm.
Commissioner Hamilton.
Thank you, Mr. Chairman. How are you doing today, young lady?
I'm doing okay. Thank you.
You're holding it pretty well, eh? Now, I've got a few questions that I've jotted down during your testimony, and the last one I jotted down, you answered the question about the Bechtel report, and you said you were not CFO at that time. What would you have seen if you had been CFO?
I don't know, Commissioner Hamilton. I don't know if I would have seen the construction report even then, and I think if I had, I still would have had to ask the construction experts on site what that report meant.
So the Bechtel report, even within the company, was limited to excess.
That's right.
Next thing you opened up talking about the uncertainty that was before the company at this time, and you talked. Of course, you're here today to put forth the two options from Dominion.
Yes, sir.
If ORS or the experimental rate were to take effect today, what would be the uncertainty as far as the company being able to survive forward as a standalone company?
I think in either of those cases, with the ORS proposal or with the Act 258 being made permanent, both require a good deal of write-offs for the company, and it would weaken our ability to access the capital markets on a regular basis with our utility peers. So in my opinion, the offers put forward with Dominion are able to accomplish a rate that's similar to what Act 258 reached, but it leaves us with a healthy utility here in the state.
Well, if it would leave you with employees that are losing their jobs too, wouldn't it?
That is true, but I will say I think Dominion has been, I work with our transition team as well, so we've started preparing some activities and comparing the way we're structured versus the way Dominion's structured. And I can say just from personal experience with that they've been very accommodating and trying to understand how we do things here and compare those to how they do things there. And it hasn't been a case of just coming in and saying, we're going to change to the Dominion way. They're trying to learn and grow together. So I feel like from that perspective, I believe them when they say that they're going to try to manage that attrition. I mean, we have a lot of employees that have been with the company 30, 40 years. And quite honestly, I think some of them would be happy to take a severance package and retire at this point. And that could open up additional opportunities for other employees who are moved around as a result of some transition.
How many employees are on the special bonus plan that has if you lose your job in a specified period?
That covers all of our officers and senior officers. So I don't have an exact number for you. I would say, I would guess that it's about 40 people, but I'd have to get that number to be sure.
So it would be fair to say that the people that are really here today talking about the merger would be in pretty good shape if it happened.
Well, I guess it depends on your perspective. So I'm here talking to you, and if I'm losing my job over the merger, I don't know if I'd agree with you that I'm in good shape. But I do. The reason that we give those to, or that those agreements exist for the officers and above, is because that is generally where you would see reductions in management during a merger. So it incents those people to stay through the merger process.
All right. Thank you very much.
Thank you.
Thank you, Mr. Chairman.
Sir, thank you. Commissioner Whitfield.
Thank you, Mr. Chairman. Thank you, too, for being with us today. Ms. Griffin, the bulk of my questions are going to be for you, but Ms. Nagy, I do have one for you before I get started with her. And I might be a little bit outside of the purview here, but it won't be the first time. So if you can't answer, I certainly understand it, and hope no attorneys jump up in the meantime. But with your expertise as a CPA and background as an accountant, I wanted to ask you this. You're aware that SC&G is seeking the federal tax credits by pursuing the abandonment so diligently, I guess I should say, and they have had to do a lot of things along the way to convince the IRS that they are in fact doing that, and that's been going on since the abandonment was announced, 14, 15 months ago. In your professional opinion as a CPA, how certain are you that SC&G will be successful in obtaining that full federal tax credit in its entirety?
Thank you for the question. I would say that that is outside of my area expertise. I'd be glad to answer questions about mergers or even Chapter 11 process, but I do not deal specifically in that area.
Okay.
I think Mr. Ward would be the appropriate witness to answer that question.
Okay. Well, I will certainly, I certainly respect that you punted that, but it is a certainly large amount and a concern that we would have. Ms. Griffin, a couple of questions here. Concerning the no merger benefits plan, on page 40 of your pre-file testimony, you state that the return on equity of 8.53, I'll give you a minute to get there. Page 40.
Yes, sir.
You state the return of equity of 8.53% is achieved only after SC&G writes off $1.1 billion in assets. What effect would a write-off of $1.1 billion in assets have on the company's cost of capital?
Well, and the $1.1 billion of asset or impairment, has already been reflected. So we've already taken that impairment in our financial statements. Mm-hmm. So that sort of takes us to current state. So at that level, our credit metrics would support an investment grade rating.
And you had a long exchange with Mr. Richardson about if these assets were ordered involuntarily, and about the discussion whether it would be an unlawful confiscation or not. Rather than go all down that path again, is it, just for the record, is it the company's position that it would be writing off prudently incurred cost?
I think that would be our position. That
you are writing off prudently, what you consider prudently considered cost.
That's right. Okay.
Got a couple of more questions here for you, and that'll probably wind us up. Ms. Griffin, ORS has testified that they do not believe that SC&G would declare bankruptcy under the optimal plan. Like to have your thoughts on that, and also if you've determined a percentage. I think I asked that question of a couple of witnesses before. Have you determined a percentage that you think the percentage number of possibility of bankruptcy under ORS's optimal plan?
Okay, and I have not determined a percentage. I think I agree with Ms. Lapson's testimony from yesterday that it's really a gradual process where you might find yourself in that situation. I would say that the ORS proposal and the resulting credit metrics would weaken the balance sheet of SCE&G, and that would make it more difficult for us to deal with other things that may come up. So you're aware we've got this proceeding here. We've talked about the Department of Revenue claim that's yet to be resolved. We have a lot of other litigation that's ongoing, some of which proposes that we refund money to ratepayers through that. So the culmination of all of those things could push us into a situation that could be dangerous for the company.
So your answer is, I guess, similar to Ms. Lapson's slippery slope answer would be your answer. You don't
Yes,
have
sir.
a number that you've really, or percentage number that you would put on it.
That's right.
Commissioner Whitfield, if I might add something, if I might ask
Certainly.
to that.
All right.
So I think that there are publicly available metrics that are used to predict the likelihood of a company going bankrupt over a period of time. And so that's certainly information that's out there and available. I do think that I understand from testimony last week that the very low percentage of closer to 0 than 1% was cited. In my experience and based on just observation of publicly available information, that is just a absurd estimate with respect to the likelihood of bankruptcy. Just based on public information, I'll give an example. Is there's a score out there that's been accepted for about 50 years that predicts within a 2-year period what the likelihood is. There are also various financial metrics used and monitored on different financial websites that also monitor a company's likelihood of bankruptcy. There are very few companies, I would speculate, that could be closer to 0% than a higher percentage than that.
Well, I certainly appreciate your response, as we can look at printed public things all day long, but we need to
Understand.
state of what's in the record of this case. So I certainly appreciate your response. Ms. Griffin, a couple more questions. Been some discussion about the PSNC business in North Carolina, an offer that was divulged earlier in the case. Do you have any type of have you had any type of offers on your Georgia SCANA services over in Georgia, your gas service over there, your subsidiary over there that, of course, is not regulated by this commission?
We will occasionally get people expressing interest in that business. It's a much smaller business, and the valuation expectations on that are much less than the business in North Carolina.
Okay. There's been a lot of, there was some testimony about and questions from my colleagues here about the executive bonuses and incentives when Mr. Addison was on the stand. Could you provide a total of executive bonuses that have been charged to the NND asset since the project began, as well as executive bonuses charged to the project since March 12, 2015?
I don't have those numbers with me, but Mr. Kevin Cocombs is going to be testifying, and we can get those numbers to you during his testimony.
During his testimony, maybe Mr. Chairman, could we add that maybe as a late filed exhibit? Both. Okay, we'll do it when he's on the stand, and 2 different types we would like, both since the inception of the project, and since the date ORS is defined, March 12, 2015. Also, like to know how much of Mr. Timmerman's contract was capitalized to the NND project. If we could also get maybe him to provide that information with that time as well.
Okay, we'll do that.
Okay. Lastly, Commissioner Hamilton asked you some questions about the merger and about employees and what may happen. We've seen, this commission has seen what happened with the Duke Progress merger. And of course, in North Carolina, they had a headquarters in Raleigh. A lot of things were relocated to Charlotte. And I think Commissioner Hamilton would tell you that things changed drastically in the Progress Service territory of the PD. What is your opinion of I know Mr. Addison said that he thought the majority, didn't put a number on it, but he thought the majority of the employees were in favor of it. We did hear from one or two linemen that were associated with the union at night hearings. But I would like to know what your opinion of the employees' feeling is toward this merger. And I'm talking about the employees that would not be covered by these bonus plans, if you will, if the merger goes through. I'm talking about not only the linemen, but other long-term South Carolina residents, long-term residents here in the state that have been with SC&G a long time. What is your knowledge of those employees and their feelings?
Yes, sir. And I think it does sort of fall into two camps. You have the operations employees who feel like there won't be a lot of changes. Dominion has said we've got a well-run company outside of this nuclear issue. We have good reliability scores, we have good operations, and so they don't plan to change that. So those employees are excited about the ability to sort of put all this behind us and be working with a company that's growing and investing and expanding. The service company employees, there's some concern there because of the uncertainty around their jobs. However, I think the more they've had a chance to interact with their Dominion counterparts and the more that they've seen from Dominion's presentations, they understand that Dominion does value them as well and is going to try to make this as painless as possible through just natural attrition.
Well, I appreciate hearing that from you. I know we're going to hear from the Dominion witnesses, and I know we're going to hear their side, but I certainly wanted to hear from you. And one last thing, you've been with the company 15 years, and you're certainly aware of what SC&G's involvement has been in economic development here in our state. And again, I know we're going to hear from the Dominion witnesses, but I would like to hear from you not only your opinion, but your notions or opinions of the employees at SC&G, what they feel the efforts might be about with economic development going forward.
My sense is that Dominion is committed to economic development in the state. They see the state as a good growth area. We still are a very attractive place for people to move and locate, and so they want to invest in that. And I think, honestly, when you look at their rate proposals, they put forth an initial rate proposal, and they received feedback on that proposal from a lot of members of the legislature and the public. And then they've now put forward another proposal that more closely mirrors the rate reduction provided for in Act 258. So I think they're interested in being a good corporate citizen and not just dictating the way things need to be done, but also listening and trying to be responsive to that.
Well, thank you, Ms. Griffin. That's all I have, Mr. Chairman.
Thank you.
Thank you. Commissioner Urban.
Thank you, Mr. Chairman. Ms. Griffin, I'm pleased to hear that you're meeting with the transition team. That shows that you're planning ahead and making progress in that regard. I'm wondering if you could tell us whether you've had some discussions with Dominion management about cost savings from the merger. We would assume there would be cost savings. Can you put a number on it?
We don't have a number at this point. We know right now we're on a PeopleSoft accounting and HR system, and they're on an SAP system. So we know there is a great deal of systems work that will need to be done, and that's going to take a period of time. They've estimated that it will take 2 years for that. So we don't know that there are going to be a lot of cost savings initially. We know, for instance, that the plan right now will be for us to continue on our own payroll system, on our own HR system for the first year or so. So I don't know that there'll be a lot of cost savings initially. We're just trying in the transition work to really be prepared, because if the merger does close, there are some things that we're required to do, such as close the books together on that first closing cycle. So we're just trying to get prepared for those types of things.
Dominion is a much larger company and has great metrics in terms of earnings and growth. So economy of scale would seem, common sense would seem to be a lot of savings there. Would you agree?
I think that could be the case. I don't know enough about how their service company is run to be able to give you that, but I'm sure their witnesses can talk a little more about that.
Thank you. Angela, you indicated in your summary that you worked as a public company controller of a utility that merged with another utility. What company was that? I'm just curious.
So I was referring specifically to the merger and integration of AGL Resources when it acquired Nicor Gas in 2011.
And which company were you with at the time?
I was the controller of AGL Resources, which with that acquisition had utilities in 7 states.
That was a publicly owned electric utility?
Yes, AGL Resources, until it was acquired by Southern Company in 2016, was the largest gas-only local distribution company.
So you've had some experience with mergers, and what kind of cost savings did you see? I know each merger is different, but just what kind of range would you expect in a merger like Dominion, SC&G if it should occur?
Sure, thank you for the question. So I do think that each merger is different, and that it's having worked through integration and helping clients more recently with integrations. It's hard work for the integrations, and it depends on the specific systems and current operating model of each company. I do think that the timing of when efficiencies are typically gained does take an amount of time. So I think the applicants, have proposed that they would not push down the cost associated with obtaining those synergies. I know that in previous testimony, the Commission has heard some numbers, and I've read that testimony associated with some mergers that were about 20 years ago. I think that given changes for 2 reasons, that's a really not reliable estimates with respect to synergies, and specifically the reasons for that are changes in technology, and that in my experience is just a very surgical hard work to identify and to implement efficiencies, and they take time, as Ms. Griffin described, particularly because of systems and the particular technologies that are important to the security and safe, reliable delivering of electricity.
You would agree with, considering Dominion's size and strength, you would think that they would bring a lot to the table to in terms of a merger like this, cost savings potential. Do you agree with that?
I would not be able to know whether that was the case. I think that there's, as Ms. Griffin described, significant differences in systems, and in order to, I think something that's different, importantly, from mergers now versus let's say 20 years ago, because those examples have been given to the Commission, are not only the technology, but the importance of security, so information security, safe, reliable delivery of electricity, but also with respect to financial controls. So Sarbanes-Oxley Act and the implementation there requires that even for service company roles, that there is a well-controlled, accurate, timely financial information, and that there's good disclosure controls.
And Dominion has all those things. Apparently, they've done quite well in some of the ratings that I've been reading about. So we would expect that. But thank you for your answer. I want to move quickly to the $85 million estimate of potential payment obligations that you say may result from contractor liens. Are you aware of any filed mechanics liens? Is that what you're referring to? Or tell me how you arrived at, how do you know these are valid liens, or do you?
So I was speaking to the treatment of the liens, not to whether those, and in fact, in my testimony, I said if the company were required to pay those amounts.
Because it would seem to me that many of those liens would, if they exist, would probably be defeated in bankruptcy. Wouldn't you think that litigation would, any litigation like that would be stayed in bankruptcy, wouldn't it?
So in the case of a bankruptcy, all amounts related to claims prior to the bankruptcy date would have to be considered, but those claims, based on the fact that they are a lien, would be considered as a claim class similar to secured creditors considered with vendors, et cetera. So it would not dissolve or in any way cause those liabilities to be not paid or considered in a bankruptcy. In fact, they would be considered, if determined valid, they'd be considered the same way vendor claims would be of people who continue to provide services to the company and live here in South Carolina.
They'd come after secured creditors, though, would they not?
Excuse me?
They would fall below secured creditors in the line of payment.
So in my experience in reviewing and assisting with accounting around plans of reorganization, yes, secured creditors stand ahead of other non-secured creditor claim classes.
Thank you. Those are all questions I have.
Thank you. Commissioner Elam.
one question, just informational. Ms. Griffin, on page 5 of your direct testimony in the 370 docket, you reference a SCANA subsidiary, South Carolina Fuel Company Incorporated.
Yes, sir.
And I'm not remembering that off the top of my head. How old is that sub?
It has been around for a long period of time, too, and it exists to purchase the fuel that SCE&G uses. And the reason we do it that way is because it's funded through short-term debt, so it's cheaper to do it that way for customers.
Okay. Like I said, I just wasn't remembering it off the top of my head. Thanks.
Mm-hmm.
Commissioners, any other questions? I've just got one, Ms. Nagy. Page 5 of your rebuttal testimony, you state that in AIR response 1-127, SE&G estimates the number of liens to be approximately 121, or totaling $289 million. When you prepared your testimony, did you review of the listing of liens and how those amounts were derived?
I did not review the underlying liens. No, sir.
Okay. All right. Commissioners, anything else? Mr. Burgess.
Mr. Chairman, we have no redirect of these witnesses, and we would ask that they be excused.
All right. Thank you both. You may be excused. Okay, tomorrow we'll reconvene at 9 o'clock a.m. We have date certain witnesses for the Coastal Conservation League and Southern Alliance for Clean Energy, as well as the South Carolina Energy Users Committee. So we'll attack the day at 9 o'clock tomorrow. And we are, yes, sir.
Mr. Chairman, I'm sorry to interrupt. This will be very brief. Today at 3:10 p.m., the joint applicants filed the testimony of Rose Jackson, which is responding to the Transco testimony. It's also testimony that we would have responded to in our rebuttal. We did not have that opportunity to do so. It's highly prejudicial to file testimony the day before our witnesses go. And so I'd either ask that that testimony be struck or that we be allowed to do a very brief rebuttal live on the stand with our witness tomorrow.
Mr. Chairman, that testimony that was submitted was with respect to the settlement agreement that Transco and SC&G and Dominion entered into. If Mr. Cleveland wishes to file a piece of responsive testimony, we would have no objection to him doing so.
Okay, we can do that.
Okay, thank you, Your Honor.
We can respond from the stand tomorrow. Is that works?
That's even better. Thank you, sir.
Okay. Anything else? Not, we're adjourned.